My lords, my name is Vincent. I'm representing my client, the appellant, Mrs. Bin, for the appeal of the conviction of murder from the Court of Appeal with my lender colleague, Mrs. Zui. My lender friend, Nash and Shah, are representing the respondent, Crown Prosecution. Lord, my lord, would you need me to brief the case?
Yes, please, if possible.
My lord, the victim, the husband of the appellant, has been suffered from serious brain cancer for the last 2 years. He was nursed by my appellant at home under the direction of the doctor. But due to the terminal illness, Mr. Bean could not cope with the suffering and the pain, and my appellant would relieve him from his suffering. So she crushed some poison into his food, and fed him. And later on, the Mr. Bean died thereafter. My lord, on the question of the mens rea for murder, the trial judge directed the jury that the test of foresight or virtual certainty adopted in Cron against Wooling, reported in year 1998, volume 4, All England Law Report, page 103, means that the result foreseen as a virtual certainty is intended result that if they found the death to be the virtually certain consequences of the defendant's act, they must find the intention. My lord, one of the key debating factors of this case is determining whether my client has the intention to kill or cause serious bodily harm to her husband. Your lordship, it is the appellant's submission that it is not proper to apply the test in Wooling based on the current circumstances in this case. Therefore, the test of foresight of a virtual certainty as applied by the House of Lords in the case of Wooling shall not be applied in this case in front of this court.
Counsel, why do you think that the Woolen test should not apply to this case?
There are three arguments that I have which the submissions believe the test shall not be applied. My lord, can I go into my argument?
Yes.
Okay. The first argument is virtual certainty may not conclude an intention. My lord, even death is a virtual certainty for the consequence of a person's action. It may not necessarily to result a requisite intention for killing or cause seriously bodily harm. For example, if I'm holding someone's hand, preventing him falling out from a window of a 20th floor building, but if, let's say, I let him go because I'm not able to hold him anymore before the help comes, in a reasonable person's eyes, my lord, if he falls down in this scenario, there is no intention to kill at all. It is obvious that virtual certainty in this scenario may not be necessary to conclude an intention. In Cron against Nedrick, reported in year 1986, volume 1 of Weekly Law Report, page 1025, N was tried for murder. He set the house on fire through the letterbox, and a child was dead because of the fire. N admitted arson, but added he did not want anyone to die for his action.
Sorry, counsel, which case are you referring to?
Nedrick.
Yeah, proceed.
The judge's direction equaled foresight with intention. This direction was overruled by the Court of Appeal, and the defendant's conviction of murder was substituted by manslaughter. In Crown against QIU, reported in year 2000, volume 2 of Criminal Appeal Report, page 407, the defendant saw a petrol bomb being thrown into a house. Knowingly, there are 6 people inside the house, and some of them was killed and some of them were seriously injured. The ruling of this case is the conviction of murder had been quashed because the menstrual of murder was not being found. Even the defendant knowingly there are 6 people in a house, and it is a virtual certainty if he don't inform if he don't take action, the people may die or injured as a virtual certain consequences. In Crown against Hancock, reported in year 1986, Law Report Appeal Cases, page 455. H and S, the 2 defendants, pushed a block of concrete from a bridge onto a motorway below the bridge, killing a taxi driver and his passenger. It is a virtual certain consequences if someone pushing a block of concrete from a bridge onto a motorway, it may hit a car, and the people on board the car may die. My Lord, in Real Attorney General's reference number 3 of year 1994, reported in 1998, Law Report Appeal Cases, page 245, B stabbed a pregnant lady, and the pregnant lady immediately gave a delivery to a baby, and the baby died after 121 days. It is a virtual certainty if someone stabbed a pregnant woman, the baby who carried by the lady may die as a virtual certain consequences if the person stabbed the woman. My Lord, do you have any question?
No.
No? You may proceed.
My second argument is there's no malice of the appellant. My Lord, in the case of Crown against Matthew, reported in year 2003, case number 192 of the England and Wales Court of Appeal Criminal Division, the defendant threw the victim into a river knowingly that the defendant is not able to swim. It is a virtual certain consequence that the victim would die if they threw him into the river. The defendant did the act after they robbed him. The act was committed with malice. My Lord, in our case, it is quite different. Mrs. Bain was trying to relieve her husband from his suffering, and knowing he was dying, and there was no possible medication able to help him. Instead of malice, the appellant's action was based on good faith and love. Therefore, the courts need to consider if it is her intention to kill or relieve him from the suffering. My Lord, do you have any questions? My Lord, my third argument is the case in front of this court is different from Woolley. My Lord, in the present case is different. It's different from the circumstances in Woolley. In Woolley, the father lost his temper and threw the boy onto the hard surface, caused serious brain damage, and later leads to the death of the child. While in our case, Mr. Bain was suffering from serious pain and he was not able to cope with his suffering. As the vision of this, the submission believes our case in front of this court should be distinguished from the case of Woolley, and the test of intention in Woolley shall not be applied. My Lord, we may refer to Adele NHS Trust against Blade, reported in year 1993, Volume 1 of Family Law Report, page 1026. The hospital was granted a declaration to remove the life support machine. My Lord, in the concept of that case, we should apply the similar concept in the case of Adele. In the view of our submission, Woolley's test for intention shall not be applied. Do you have any questions, my Lord?
No.
So, in summary, Counsel, what is your submission to say that? Sorry, if you shall repeat your submission.
Sorry?
What is your submission to
My
the court?
submission today is the Wooling's test shall not be applied for determining the intention of manslaughter of murder.
All right. Counsel, because now I referring to the grant of appeal granted by the Court of Appeal, because the Court of Appeal say that whether if a consequence is foreseen by the defendant has virtually certain to occur, the jury must find that the defendant did have the requisite intent for the manslaughter of murder.
Yes.
So now do you think that the jury must find the defendant to have the manslaughter of murder in your submission?
My lord, I have some further argument in supporting my submission.
Okay.
If you allow me to move forward. My lord, Lord Chief Justice Lane stated in his opinion in the case of Nedrick, the jury should be directed that they are not entitled to infer the necessary intention unless they feel that the death or serious bodily harm was virtual certainty as a result of the defendant's act, and that the defendant appreciate that such was the case. My lord, further to this, in the case of Wooling, Lord Stain referred Lord Chief Justice Lane's opinion in Nedrick's case twice. The language his lordship used in his judgment is the jury may find the intent to kill or cause serious bodily harm, while during the trial in our case, the jury was directed as they must find the intention to kill or cause serious bodily harm. The jury should be given freedom to decide. The trial judge should not influence the decision of the jury. It is a clear misdirection of the judge during the trial to the jury. My lord, please allow me to conclude my argument. My lord, as per the appellant's submission, virtual certainty does not necessarily to be able to lead to an intention to kill. And also, the circumstances in the present case are different from Wooling. Therefore, the Wooling's test of intention shall not be applied. In addition, even if the Wooling's test applies, the trial judge had misdirected the jury. Your Lordship, based on the ground of my client's submission, I would urge this court on my client's behalf allow the appeal to crush the conviction of murder. That, my lord, concludes my arguments. I wish to submit on behalf of the appellant. Are there any further issues I may assist?
No? Thank you.
I'm obligated, my lord.